Hollywood losing lawsuit claiming right to not hire white writers in the first major DEI lawsuit. This lawsuit has been going on for a few months. It happened before the Gina Carano and Disney lawsuit, where Disney had a similar defense, that Hollywood companies have a right to hire people of the skin color of their choice because they're doing creative work. And then they also claim that you can't judge them based on state discrimination laws, because they have a First Amendment right as a corporation to make creative statements. And their TV shows, their movies, they're all creative statements. That's their defense. They also rely on the Boy Scouts discriminating against a gay scoutmaster. As far as Hollywood's concerned, they can discriminate against anyone based on their skin color or any reason they decide because they're producing creative works. They literally claim discrimination law does not apply to them. Well, what's now happened in the Paramount lawsuit is just like Disney, they've lost a motion to dismiss with the judge. It's so bad for them. The judge's opinion, and this is a federal court judge, is that the papers are enough to decide, no, this can't be just dismissed. And no, we're not having a hearing over it. I don't want to hear from both sides. I can decide this just on the papers, the filings. Which means, no, the federal courts don't even need to have a hearing to hear from both sides to decide, is this worthy to go forward? It is worthy to go forward. This judge has said, just like in the Gina Carano suit, the lawsuit moves forward. Paramount will file for a summary judgment and that will be heard. It's not impossible they could win, but it's pretty unlikely they could win. Because if the cases against Disney and the cases against Paramount had no merit, if they really did have the legal right to discriminate against people literally just based on their skin color or on their political beliefs, then both of their cases, the Carano cases and the Spinnaker case, would have been thrown out at the motion to dismiss phase. From The Hollywood Reporter, CBS loses bid to dismiss lawsuit from SEAL Team writer over alleged racial quotas for hiring writers. The studio claims that its shows constitute artistic speech and that it's allowed to choose the writers who convey its message. The court's order referenced another judge advancing a similar discrimination lawsuit from Gina Carano against Disney and Lucasfilm. And look how important it is to have these lawsuits going on. Maybe Gina Carano wins, maybe she doesn't. But because there's a pending lawsuit with a similar issue, the federal judge can't just go and dismiss this. Because the people suing have already demonstrated there's some value to their claims. Here's what Disney's argument was on the Gina Carano lawsuit. Disney argued that there's a First Amendment right to choose employees who properly convey their values, even when those choices would otherwise violate state anti-discrimination laws. It cited the Supreme Court in Boy Scouts of America versus Dale, finding that the organization's decision to fire an openly gay assistant scoutmaster is protected under the Constitution. That constitutional right, the court concluded, shields the Scouts from violations of New Jersey discrimination laws. I don't know that case very well. But the Boy Scouts, even if they got that little win, that was decades ago. And since that win, the Boy Scouts have been absolutely eviscerated. If that case was to go to court now, of course it wouldn't win. But the reason that case went to the Supreme Court in the first place is if you're an employer and you want to discriminate against people because of their skin color or because of their sexual preferences or because of their religion, there's going to be some lawsuits over that. Eventually, someone's going to sue. And then it's going to get fought out. And if it's obvious, it'll get killed immediately. The employer will win or the employee will win. If it's not so obvious, it may, like the Boy Scouts, actually wind up in the Supreme Court. Here's the nature of the lawsuit between the SEAL Team writer and Paramount. From The Hollywood Reporter, CBS sued by SEAL Team writer over alleged racial quotas for hiring writers, which does sound like an extreme claim, but we know a lot of this is going on. There's a lot of discrimination going on because studios and big companies are pushing a political and racial agenda right now. And the backlash has been immense. That's why diversity, equity, and inclusion is getting pulled out of companies. Brian Benneker, a script coordinator on SEAL Team, who claims heterosexual white men need extra qualifications to be hired on the network shows, is represented by a conservative group founded by Trump administration superstar Stephen Miller. And I put the superstar in there because the stories about these guys keep coming up again and again. Here's what America First Legal has to say about their recent win in the Paramount lawsuit for Brian Benneker. They're doing all of this on behalf of Brian Bedecker, but really on behalf of all Americans. From America First Legal, federal court rejects CBS's attempt to dismantle AFL lawsuit for alleged anti-white racism. The U.S. District Court for the Central District of California rejected CBS's attempt to dismiss a lawsuit America First Legal filed on behalf of its client, which alleged anti-white racial discrimination by CBS. CBS, owned by Paramount Global, right now, they've just announced they're laying off 15% of all their employees. And in addition to that, they've just shut down Paramount TV studios, and not to be shut down over the next couple months. They announced it on last Tuesday, and they said they were closing by Friday. So they gave the employees like 3 days notice or something. I don't even know how you get your stuff out of the offices that quickly. In February 2024, America First Legal sued CBS on behalf of a heterosexual male script coordinator and freelance scriptwriter who has consistently written episodes for CBS's SEAL Team television series since 2017. So for years, they gave him work, working on the show. It's not like the guy can't write. It's not like he doesn't have the skills. He just doesn't have the preferred skin color. CBS allegedly refused to hire Brian Bedecker as a full-time staff writer for the show because he failed to check the right diversity boxes. Instead, CBS hired a black male with little experience. Well, how are they going to explain that? That's going to come up in the lawsuit. That's what CBS and Paramount don't want to have come up in the lawsuit, because it's indefensible. The real reason? I'll point to it in a second. The court's rejection of CBS's attempt to dismiss the case is a significant development. America First Legal can now engage in extensive discovery to obtain and reveal evidence of CBS's employment practices and its alleged discrimination against America First Legal's client, and can then use that information to vindicate his rights in court at trial. The evidence will show that CBS engaged in illegal discrimination on the basis of race and that AFL looks forward to obtaining ultimate victory for their client. Now, who's responsible for all of this nonsense at Paramount? Well, ultimately the stockholders, because they own the company, at least for now. The company's being bought. But it's the management. It's the creepy management that will go ahead and discriminate against people just based on their skin color, or their race, or their religion, or their sexual preferences. They feel like it's just up to them. And who's the kingpin over there? Well, if you go to leadership over at Paramount.com, you've got the 3 CEOs. You've got a few more people. And then at the bottom, the person in charge of DEI for Paramount, affecting all of their company and really affecting all of the industry. We'll get into that in a moment. Is Marva Smalls, Executive Vice President, Global Head of Inclusion at Paramount, and Executive Vice President for Public Affairs for Nickelodeon. But she's the only one with an inclusion title listed on Paramount's leadership page. She's an Executive VP. That's not a trivial position. None of their executive positions on their leadership page on Paramount.com are trivial positions. These are executive important positions, making decisions and making things happen at the company. And if you weren't completely sure what was going on over at Paramount, from The Hollywood Reporter, how Paramount wants to be a model for the industry on inclusion. Events on hip-hop and anti-Semitism are included in Paramount Global's 5th annual Inclusion Week, which the entertainment giant says is core to its business success. Business success? The company's falling apart. This was just October 25th, 2023, so recently after the attacks in Israel. And that's likely where the anti-Semitism part came from. Of course, until Paramount announces they're going to reject and denounce all of this racial nonsense, they're still going to be poisoning the company. U.S. District Judge John Walter, in an order issued Tuesday evening, rebuffed parent company Paramount's bid to dismiss this lawsuit. He found that certain issues, like whether the First Amendment affords productions broad protections in choosing talent for their movies and TV shows, would be more appropriately resolved at a later stage of the litigation. And that ruling, by definition, states, no, you do not have unlimited rights. We need to see what some of the evidence is, some of the information, some of your decision-making process. Because if your decision-making process is, I don't like the look of this guy, he's got the wrong skin color, that's not going to be acceptable in this court. The ruling was issued without oral arguments, so there was no hearing where people were actually discussing and fighting for each of their sides, and cited another judge's decision to advance a discrimination lawsuit from Gina Carano against Disney and Lucasfilm over her firing from The Mandalorian. The court in that case rejected arguments that the actress's claims are barred on free speech grounds. I don't know if you remember this a few years ago, but they told us that women are actors. You can't gender the acting profession. You're supposed to call men actors and you're supposed to call women actors. But now they're back to actresses, whatever. If you listen to my videos, you know I tend to ignore those kinds of things. Instead, the court said she may have been terminated in retaliation for holding disfavored political beliefs. Also, like race or religion, not a reason you can fire someone. Disney, like CBS in its defense in the lawsuit from SEAL Team script coordinator Brian Beneker, had argued it's entitled to select the people who convey its message in its content. And I tend to agree with that. I do think that companies have a right to decide who's going to work for them, not based on their skin color or their religion or sexual preferences. It's got to be based on their work. That's the thing Hollywood has gotten disconnected from. You can't just hire people based on what they look like, or because someone at your company decided we need to hire this many people of this religious background or whatever it is. You've got to hire based on merit, and you've got to give people an opportunity. I don't want anyone telling me who I have to hire as a writer when I'm working on a creative project. But at the same time, I'm never going to discriminate against someone and say, you can't even be considered because you have the wrong skin color. In arguing to try to get the case dismissed, CBS claimed broad First Amendment protections. Even if Beneker's claims that he was repeatedly passed over for a writing role because the studio chose to prioritize diversity, the company said that it's on solid legal ground. Quote, limiting CBS's ability to select the writers of its choice, as Beneker seeks to do here, unconstitutionally impairs CBS's ability to shape its message, according to Molly Lenz, a lawyer for the studio in a court filing. It continued, because CBS's works are expressive, CBS has the right to select employees whose work affects that expression. The issue will be decided at summary judgment according to the court, and that is the decider of these kinds of things. The lawsuit's not over. That's the key element of this. No, CBS does not have an unlimited right. If they had that unlimited right, the court would have just dismissed the case. Here's what the court said in their actual order. On June 24th, defendant CBS Studios filed a motion to dismiss. On July 15th, plaintiff Brian Beneker filed his opposition. On July 29th, defendant filed a reply. Pursuant to Rule 78 of the Federal Rules of Civil Procedure and Local Rule 715, the court finds this matter is appropriate for decision without oral argument. Not even allowed to make your case. Sorry, Paramount. There was a hearing that was scheduled for August 19th, and it is now announced from the judge it was hereby canceled, and the matter is taken off the calendar. After considering the moving, opposing, and reply papers and the arguments therein, the court ruled as follows. A motion to dismiss brought pursuant to Federal Rules of Civil Procedure tests the legal sufficiency of the claims asserted in the complaint. The court then goes on to say, in deciding a motion to dismiss, a court must accept as true the allegations of the complaint and must construe those allegations in the light most favorable to the non-moving party. If you want a case where someone's making a complaint against you to be dismissed, such as it's got no merit, the judge is explaining you need to consider the person suing you and consider them in the most positive light and consider everything they're saying is true. Would you still get rid of the case? Is it still a nuisance case, a waste of time, with completely no merit? If you saw everything the way that Brian Beneker sees it, the plaintiff, if you agreed with the plaintiff, and this judge says no. Disney got shut down on their motion to dismiss. Now Paramount gets shut down on their motion to dismiss. And not only did they get shut down on a motion to dismiss, Paramount didn't even get a chance to have a hearing. And not only did they not get a chance to have a hearing to try to make their case in front of the court, they had a hearing. It was scheduled. The judge canceled it because when the judge went over the papers, he said, wait a minute, I've seen all the papers and you know something? No, you of course you can't just openly say, I'm going to not hire people because of a certain skin color or a gender or a sexual preference. You can say you don't want to hire someone who doesn't have the skills. You can say you don't want to hire someone because they haven't proven themselves yet. I'm going to hire someone who's more qualified. Paramount did literally the opposite of that. They had a guy working for them, writing scripts since 2017. Let him continue to write scripts on a freelance basis, but wouldn't give him a permanent staff position. So they then gave a permanent staff position to someone who had a different skin color, who had less experience, and excluded this guy because he's white? That looks like what they did. The evidence will still have to come out. But as America First Legal explained, now they get access to discovery. Now they get access to internal emails, internal conversations, policy papers, all kinds of things that would have led to the decision to hire the person who wasn't as qualified because he had a certain skin color, and to continually pass over a guy who could have done the job, has already proven he's done the job, but didn't advance their political agenda. Excellent, excellent development for this lawsuit. I'll continue to cover it on this channel. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.